Sorry to interrupt right out of the get-go, but I think that the microphone is picking up from your laptop and not from the Candow camera, because I can't hear Brooke at all. So if you go to the little drop down next to your microphone.
This one? This Candow on my end.
The microphone is definitely picking up your laptop and not the Candow.
Yeah. Looks like it clicked. That's speaker. Oh, microphone. Sorry, go back.
Oops.
Just a bit.
Yep.
It's this.
I know. Does that sound bad?
That sounds better, Pete. I can hear you standing up there, so I think that resolved the issue.
Patty, thank you for everyone.
And just gonna say that you in the room are definitely gonna need to speak up. We can hear you, but it is, just be loud.
Gotcha. Thanks, Patty. Appreciate it. Is this loud enough?
Yes.
Okay, great. Wait, hold on.
Maddie, I turned up the volume to the max.
Welcome to meeting number 3 of the appeals study for Act 181. I am thrilled in the engagement that we've had over the last few weeks. We have had some great minds getting together and providing us with models and ideas about how to either improve the court system the process that we are currently involved with, or to build some board models so that we can analyze and determine what models might provide for more expedient appeals in the Administrative Procedures Act arena, as opposed to the traditional judicial branch of the government. And we started out with Liam Murphy, MSK's existing model, which was terrific. Liam, we appreciate that so much. And then MSK had a possible board role in terms of appeals, limited to Act 250 appeals. And then they also provided what their recommendation would be for an expanded environmental division jurisdiction. We then had David Mears put together a very comprehensive APA model, I'll call it, with ALJ, hearing officers, administrative law judge type people. So we'd like to delve into that one as well today. And then the NRC, John Groveman, recently provided us with some feedback that really gets to the heart of the role of how the board could take over in terms of appellate functions. So we would love to get into those today and to discuss them. I would love to put our authors on the spot. And haven't talked with Liam before this moment, but hopefully he can help us to present and explain the models that he put forward, as well as for John and Dave. So, but before we get there, let's start off, please, by introducing everyone who is here in the room. And then I'd like to go through the online folks. It's been about a month since we have met before, and we do have some new folks joining us. And I'd like to welcome Representative Mahali here. He is here in person. We're thrilled to have him aboard to go through the stakeholder process, observe, and help guide where we're going on this. So I will go to my right, and why don't we go around the room and just remind each other, if we're not acquainted yet, of course. And Ed Stanek, I see, is here today. We're thrilled to have you, Mr. Stanek. Thank you so much for coming. I'm going to turn it over to my right, and this is Pete Kopsko. So please introduce yourself and tell us who you are.
Pete Kopsko, District 3 Coordinator.
Thomas Weiss, Citizen Stakeholder from Montpelier. Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce, and was part of the stakeholder group in the updates to Act 250 in 2020.
Warren Coleman, I'm here for the Musketeer Association.
Kirsten Saltian, I'm a board member. And I'll mention too, I was a longtime coordinator for Act 250 for District 7, which is the Northeast State. Happy to be on the board with many thoughts.
I'm Ben Stanek, former District 5 Act 250 coordinator, and I live in Bear City.
Alex Pastor, I work for the Land Use Review Board. Elizabeth Bridgewater with the Wyndham and Windsor Housing Trust, a housing provider in Southeast Vermont.
I'm Kathy Beyer. I work for Evernorth, which works statewide in affordable housing, building affordable housing.
David Mears with Karen Gillies and Shims.
John Groban with the Vermont Natural Resources Council.
Mark Mahawi, House General and Housing, and formerly of the law school. Right, failed with retirement.
Ron Shims with Karen Gillis and Shims, and a former Anarchy Shem.
Holly Major with the Vermont Housing and Conservation Board.
Samantha Sheehan with the Vermont League of Cities and Towns.
Great, all righty. Now online, I guess I'll.
We have one more gentleman in the back.
Oh, I'm sorry.
That's okay. I'm sitting back here because I'm unfortunately double booked and I wanted to see a bit about what was going on, but I can't participate as much as I would like to. I'm Larry Sackwitz. I'm a representative from Round Rock. I'm ranking member of the House Environment Committee.
So nice to welcome you. Thanks for coming. So Alex, would you like to call off the people online?
Maddie's gonna do it.
Oh, I apologize. I cannot see that.
Right.
I'm so sorry.
No, that's fine.
Maddie's like-
I'll kick it off. My name is Madeline Cotter. I'm a tech with the Land Use Review Board. And we'll go to Annette.
Annette Smith, Vermonters for a Clean Environment, Danby.
Then I see Austin. Maybe that's someone's last name, not sure. Okay, maybe we'll come back to Austin. Brian Bannon,
Hi, Brian Bannon, Town of Brattleboro zoning administrator.
Catherine Dimitrik,
I'm Catherine Dimitruk, Northwest Regional Planning Commission, and I'm representing BAPTA.
Rebecca Shalafo.
Sorry, Maddie, we couldn't hear that.
That was Catherine Dimitrik introducing herself. Moving on to Rebecca Shalafo.
Good afternoon. I'm Rebecca Shalafo. I'm one of the attorneys with the Land Use Review Board.
Chris Roy.
Good afternoon. I'm Chris Roy, one of the directors with Downs Racklin Martin and a former member of the former Vermont Environmental Board back in the 2000s.
Billy Coster.
Good afternoon. I'm Billy Coster, Director of Planning and Policy for the Vermont Agency of Natural Resources.
Elizabeth Filosa.
Hi, I'm Lizzie Filosa. I'm the staff attorney of the Environmental Division.
Jeff Hand.
Good afternoon, Jeff Han from SRH Law, and I'm only going to be on for about 45 minutes. I have a high school graduation starting at 2.
Jim Dumont.
Jim Dumont, attorney, Bristol.
John Kessler. Maybe John's having some mic issues. John Kessler is
Sorry.
here.
John Kessler, Agency of Commerce and Community Development, Montpelier.
Liam Murphy.
Good afternoon, Liam Murphy from MSK Attorneys in Burlington.
Merrill Bent.
Hi, Merrill Bent. I'm an attorney at Wilmington, Campbell, Benton, Stasny in Manchester.
Peter Paggi.
Hi, Peter Paggi with Wyndham and Windsor Housing Trust.
Peter Tucker.
Hi, everybody. Peter Tucker with the Vermont Association of Realtors.
John Zakowski.
Likowski, attorney with Agency of Natural Resources.
And then Allison Stone.
Good afternoon, Allison Stone, General Counsel of the Land Use Review Board.
That's everybody.
Terrific. Well, thank you all for attending in person and online. We so appreciate your input and your attention to this important matter. As we discussed before, we have been trying to focus on identifying the best issues to accomplish the goals of making housing appeals faster, trying to find alternatives to ensure that Act 250 is not an impediment time-wise, and to make sure that while due process is certainly preserved, we are trying to build the best models that we can for alternative appellate body review. And so we're trying to avoid the court versus the board debate at this point and just create the best options that the board will be able to choose from to try to make recommendations to the legislature. We envision perhaps making a recommendation about if the court system is going to be retained. These are some things that we believe may increase the likelihood of reaching that goal. Or here are a board or some board models that also might work and might be able to speed things up as well. So what we're trying to do is create the best options. And in the end, we can certainly engage in a debate. And through the process, I anticipate doing that because I think there are some real pros to going to a board model, but there are many pros to staying with the court model. And that's been the inability of folks to come to a consensus about that very issue. But we feel that it's the board's role here to identify and recommend the best options. And ultimately, the legislature will determine which is the best choice. So we really appreciate your getting involved in trying to find the best mechanisms, whether it's standards of review, standing, what have you, to bring together a process that preserves due process, allows neighbors to have a say, but is not a problem for developers and is predictable. So having said that, when people want to speak, please raise your hand. And if you could try to remember to say your name. We're not attributing comments in our note taking, but we are trying to make sure that everyone else understands who's talking, especially the people here in this room, because it's hard to discern when you're online who actually in the room is speaking. And again, as Maddie cautioned us, please try to keep your voice up. That's very challenging at times. It's easy to forget. I had sent out some additional information over the past couple of weeks as we looked at data and information to try to give you some thumbnail information about some of the questions that arose during our last two meetings. And so I placed those into the summary of the stakeholder process document to try to make sure that people had that information readily available, could eyeball it, take a look at it. What we've tried to do is, I'm going to try to share my screen here just to focus you on that, that actual document. And I'm on page 13 of it. This is the additional materials that have been provided. We gave some information about the definitions of what happens at the court, consolidation versus coordination. Allison Stone was able to clarify that for us because there was a lot of debate and misunderstanding. The bottom line was that either coordination or consolidation can happen at the court. But as the discussion revealed, timing often is up to the developer, and there are lots of reasons why things are not done at the same time. They're done in more of a serial fashion. Financing, whatever those issues might be. So in terms of coordination and consolidation, it sounded like there was a discussion about it, but either way, having one-stop shopping where those project permitting decisions can be coordinated on appeal in one location. That seemed to be the goal, and it is accomplished in the environmental division, though it's used not frequently, I guess I would characterize it. So that was just to clarify things. We also had our Associate General Counsel, Jenny Ronas. She compiled statistics because one of the questions was, how many Act 250 appeals are from permits that are issued or versus permits that are denied? And so in the last 2 calendar years, the issued permits, and you want to see the incoming appeals. So that's the second column that I highlighted. There were 6 permits that were issued that were appealed, obviously by not the developer. And the permit denials, there was 1. In 2024, there were 3 appeals of permits that were issued and only 1 appeal of a permit denied. So in terms of the breakdown, it appears that it is the opponents to a permit, at least in 23 and 24, that was more frequent. But the numbers are very small, as you can see. We're only talking about 7 appeals in 23 and 4 appeals. Not to say that they aren't critically important projects, and they created great angst and problems in terms of the timing and how long it took to process those appeals. But we were being asked who is doing the appeals.
Or can I ask a question, Megan Sullivan? For the appeals for projects that were denied, do you have any context over what those were? Just curious if those shared any similarities in terms of
I did not look
region or type.
Yeah, I haven't connected the dots on all of that. We're also looking at the last 2 years dockets of all of the cases to try to find a way to describe those things without going into actual case studies. I'm not sure we're going to be able to answer that specific question, but we're trying to assemble information that will be useful in giving context and understanding to what's happening.
Okay.
Because it's important to understand that so that we can try to solve and get to those goals that we've specified. Now, the permits issued versus permits denied was questioned, and then there was a specific question about who's appealing. Is it applicants or interested parties? Again, the appeals initiated in calendar year 2023. It's out of 13. And you have to understand that the chart above is talking about just permitting. The chart that we're looking at here also includes like JMs. So that's why the numbers are not consistent. This is a bigger grouping of cases. These are all of the appeals, not the permitting solely. And so what we're seeing is in 2023, it was half and half, 6 and 7. And then of the appeals initiated in 2024, it was 6 and 3. There were more appeals by the permittee than neighbors or a municipality. Now, what types of housing projects are being appealed? Because it's important to understand, is this an issue with single family homes, or are we talking about priority housing projects? And looking at these statistics, we had 2 single family house appeals come in 23, 0 in 24. There was 1 priority housing that came in 2023 to the court, 0 in 2024, and then other non-priority housing projects, 2 in 2023 and 3 in 2024. So as you can see, the numbers are not big, but as we will see with the case studies we're going to move into in a minute, they're significant, even if they're not large in number, because of what is happening for the duration of the traveling through the appeals process. Yeah, Warren.
Sure, Warren Coleman, just to be clear, are the cases actively litigated, represented, or basically litigated at the district commission level? Is that what that number represents? And then the next number is those that were appealed, and what is actively litigated?
No, that means, so there are, say, 150 cases that come into the governmental court per year, 130, 100 to 150. And outgoing, there's like 100. Or now they're at a very high clearance rate, so they're actually above 100%. But what this is talking about is how many cases at the environmental division were actually litigated. It's not how many came in or how many came out. It's how many during that 12-month period were actively litigated, open cases.
And then the next chart about how they were disposed, the ones that didn't go to trial, it could have been a summary judgment, it could have been other ways to dispose of without the trial.
Exactly.
Okay.
So, so it's a little bit challenging. You have to think about some of the statistics are incoming and outgoing, and others are what's going on during that time period of court.
Okay.
One clarifying question as well. These are all appeals of Act 250 permits, correct? They're not capturing appeals of other zoning permits.
That's right. We are focusing right now, because our staff has kept track of, the cases that the lawyer was a party to at the court. Because, say the district commission makes a decision that gets appealed, we get to be a party like a town would become, a select board could show up at the environmental division from an appeal of their DRB. So that's our role at the environmental division, is to actually be a party. And as a party, the land use review board is able to settle cases. And typically in our judicial system, I don't think it's, I think it's fair to say that our judicial system depends on case settlement. The overwhelming majority, and you hear typically statistics of 95% of cases never go to trial in our system. They take an off-ramp settlement or dismissed on summary judgment, or those kinds of short circuiting ever getting to a merits hearing. And so what we
Hey, Brooke, could I ask a quick question? On this chart
Billy, sure.
this is Billy Coster, this chart that you have up, I thought I just heard you say that all these appeals involved the NRB as a party and therefore were appeals of Act 250 permits. But it's my understanding that these numbers far exceed the level of appeal of Act 250 permits. So could you just clarify what these totals at the bottom represent?
Okay, so this number 13 are the number of Act 250 appeals that came into the environmental division in 2023. The number to the left, 32, this column, this is still Act 250 appeals, but they're what is being worked on at the case in 2023. So this number has to encompass everything that's at the court in January 2023, what cases are active at the court, plus the ones that come in during 2023.
Okay.
This is an internal data that is kept about what our lawyers are doing and working on. So
And this includes JOs as well. Is that what you were saying?
I think it should be all of yes, it should be all of the
Okay.
appeals. It's, I think, actively litigated. That column is to distinguish from the appeals initiated in the next column. So it's, if we have, a lot of our cases take more than a year to resolve. So at any given time, or in 2023, we had 32 cases that were pending during the year that
Okay.
At that point, either Jenny or I had appeared as counsel of record in.
Thank you.
But yep.
Yeah, and we don't have the number of how many were disposed of in this particular chart. But so if we go to the next pie charts, and this is from the judiciary statistics. This shows method of disposition, which goes to the question of how many cases were actually tried at a hearing by the court, or were dismissed on summary judgment, or were settled through a settlement agreement and then dismissed. And so what we're seeing for the last 2 years, and so they call it the outgoing cases, how many cases went out and how was it that they were disposed of? So in 2024, we're seeing out of the 133, oh, I'm sorry, that's not right. Out of the, all right, they don't have totals on here, but they have for non-trial disposition, which is those dismissal before you ever get to a trial. That is 81% of the cases that went out and were decided in 2024. 81% of the docket was dismissed without getting any kind of hearing. And then the bench trial, 31 cases, which was 19%, actually went through the hearing process with decisions being made by the court. That's higher than normal, like if you just look at typical civil litigation, which is more in the 95% range. You go over to the 2023, the year before, for outgoing cases, and 117, 91% that's more typical for regular litigation. That is 91% got dismissed, never had to go to the actual hearing. And that is not to say that there wasn't significant work done and motions filed in time that was needed to process them, but they didn't actually require a hearing. And then, of course, the bench trial, 12 of them, 9% actually went to a hearing and with a decision issued by the court.
So CARES consultant, if I may, and these are all of the environmental court. This is not just Act 250.
Yes, this is the entire environmental court docket. So just a subset of that, obviously, is the Act 250 cases. And yeah.
I saw that stuff.
No, that's really good point. This is the entire environmental court docket, which includes.
There's a question on one too. Sorry.
Liam, yeah.
I think you just want to get your math correctly. It's you add the 31 to the 133 for the total, because there's 133 non-trial, 31 bench trial. So the total number of trials is actually 162, not 133. So it should be 31 out of 162. And in the other one, it should be 12 out of 129. I think you got the percentage right, but you just have the numbers wrong.
I think these are those the court's documents? Or court pie charts?
Sorry, Al.
I just wondered if those were the environmental courts that was taken from their report, but it doesn't matter.
It's just a matter of numbers.
You're right.
You're right.
Yes. I'm not disputing
it's two numbers you add together.
Right. So in 2023, there were 129 cases disposed of. 117 of them were non-trial dispositions, 12 of them were trial.
May I just ask a question again? Of these, what's most important is this doesn't tell us of that 129 or 162, how many of them were Act 250 cases and how many of the Act 250 cases went to bench trials.
We are working on going through by docket number. We have about 300 docket numbers to look up, and we are working on that research to try to get more granular in our data to determine that. I would venture to guess maybe.
Well, one way to think about it is in the chart above, you have 32 active Act 250 cases. And if there were in 2023, 129, you would say there'd be 32 of the 129 and 28 of the 162 would be Act 250 cases. If that's what those charts are supposed to be reflecting is the number of active Act 250 cases. I mean, that gives you a sense that it's the percentage of Act 250 cases in the environmental court is actually pretty small.
Yes, I would agree with that.
That was I wanted to pick up on that point. Elizabeth Bridgewater. I think earlier you reported that the municipal appeals were much higher than the Act 250 appeals. So I'm wondering if there's data with similar breakdowns of how they were resolved on the municipal side.
Not yet, and frankly, disposition of the cases is not one of the columns we've been tracking as I've been doing the, docket number after docket number. That was not one of the columns that I set up, so we may have to double back if that's most important. So there may be an easier way that Allison can help us find them to give you that information.
I think it would just be helpful to use the same data that you're pulling for the Act 250 for the municipal, just to have the sense, because one of the choices later on is whether to move the municipal or keep the municipal appeals in the environmental court, move the Act 250 over to the LURB. And so just getting a sense of both of those kind of conditions and characteristics would be, I think, helpful to that discussion.
Thomas?
Thomas Weiss, Montpelier. There's also a third category nobody's mentioned is the DEC appeals, the AMR appeals.
Well, they would be.
And so they would figure into the pie charts. So.
Yeah, there is
it's not a matter of just taking the Act 250 appeals, how they get resolved, and then subtracting those numbers out of the pie charts. That give you both the municipal and the AM.
Thanks. As you do the work of reviewing the prior dockets, I think it's really useful to understand the reason that an appeal did not go to trial. And was it related to a lack of standing by the intervener? Was it the permit holder / developer giving up? Like, did that project not happen? Or was it an agreement that was negotiated? Or was it another resolution that happened before escalating to trial? Because I think those are three really different outcomes and relate to the ongoing policy discussion regarding appeals has mostly been about standing. And if that statute needs to be changed or clarified or can be changed or clarified. And so I would be curious if 80% of appeals are not going to trial, and if 80% of those are because the intervener had no standing under the statute, I think that would be useful to know in the policy debate.
Most of the Act 250 cases are getting resolved through settlement. It's not because somebody didn't have standing. And I'm not sure, I think these are court statistics for the pie chart. So I'm not sure if they're, with cases that are resolved on summary judgment motions, for example. I don't know if that's, maybe that's probably falling in the non-trial category, but yeah, it's typically settlement.
Yeah, the information that you're looking for, I think there are two challenges to it. One is just the time that we have. I don't know that we have the ability to go into that depth of research, and I'm not sure that we necessarily, I mean, certainly we could figure out, like, were there challenges to standing, and was there a summary judgment decision, a court decision on standing, because they issue a written decision on summary judgment motions anyway. In terms of settlement, I think it's going to be very challenging to discern why a case was settled between the parties because it could be from myriad of reasons. It could be lack of resources to be able to litigate all the way through. I really don't have a case and, you know, I've gone as far as I can. You know, it's just such a continuum of circumstances that I think would be very difficult to suggest. We could probably get the number of settlement agreements, but you're talking about a huge amount of time to look at 300 docket numbers, go into the documents, figure out, oh, there's a summary judgment. What does it say? What's the decision? Just the 2 case studies that I'm presenting took several hours for me to look at and to chase down all of the decisions and docket numbers in that. So I appreciate wanting to have that information. I would venture to guess that settlement will happen anyway, no matter what model you have. Maybe not to the extent that it does, but there are lots of reasons why parties end up having to not wait for as long as trial is going to take or other reasons. So I will see what we can do in terms of trying to determine that information if we can find it in a reasonable time situation. Kathy.
Kathy Byer, and I am not an attorney, as many of you already know, but I'd be interested to see what you say. My experience that I would be surprised. I'd be very surprised if the majority of the appeals were challenging standing. And one of the reasons is the developer working with their attorney may make the decision like, I am not going to spend time in court challenging standing. I'm going to the issue of the appeal, and I'm going to prevail on the issue of the appeal, hopefully. So I wouldn't want that thought out there that a significant number of appeals are around standing.
That was shared in a previous meeting by attorneys, which is why I placed it.
Sorry.
Yeah.
Because I'm not an
That was shared. I mean, we could check the record, but I'm pretty sure in the first meeting, that was the point of discussion that the majority of the time that is spent on the appeals process is in determining the standing of the intervener.
Yeah, I don't think that's accurate. I don't think the majority of time is spent on standing, but regardless, standing has been made an issue. I mean, quite frankly, because the administration has made it a focal point of an issue in the legislature. You know, my feeling has been, and why I think this group is here is because I think the issue is more systemic. It's not about, I don't think the problem gets solved by, and I wrote this in my proposal when we get to it, it's by trying to eliminate appeal rights. I think there are legal issues with that. There's fairness issues with that. I don't think it will actually solve the problem. I think the solution is a better appeal system. And to that end, I think the important numbers are that on the first appeals meeting we went through is that there are a lot of zoning appeals. I don't remember what the exact number, but it was large. There are not as many Act 250.
It was 138, which is
That's all.
about
Well, that's
what's reflected here.
There's a lot more than
That's
the Act
the doc-
250 appeals and a lot more than the A&R appeals. And so how do we create an appeal system that can process all of these appeals, especially with housing, you know, wanting to move all appeals through the system efficiently, in a fair way, and getting, you know, quality review and decision. And so anyway, I think it's good to look at these numbers, but I would hate for the LRB to like kind of have to go chasing down more statistics. You know, I don't know how much it will at the end of the day tell us basically.
Yeah, just to jump back to the original statistics that we provided, which the court was nice enough to break down for us. This was not in their normal reporting, but Judge Stoney arranged for us to have a breakdown of, you know, how many cases were filed in 22, 23, and 24. These are on pages 7 and 8 of the summary document. And the numbers look like, you know, there's 135 to 140 some odd cases filed in the environmental division per year. And this is broken down according to which kind of appeal it was. And municipal is, 3 times the docket of Act 250 system. We have 60 versus 20, 62 versus 19. I'm sorry, I'm giving you the wrong numbers. 10 versus 61. 19 versus 62 and 12 versus 47. So yes, the majority of the docket definitely is the municipal zoning cases for sure. And the Act 250 is a fairly small number. So let's see. Let's go back to the number. So this was just to give folks an idea that even though you may not require a merits hearing or that's not how the case ends, even the other cases when they're on appeal are taking time. Motion practice takes time, etc. So we can try to see what other information we can get, but we are on a short timeline. So we do want to make sure that we focus our energies on things that are going to move forward in terms of trying to resolve these, but I totally understand your concern. I'm then trying to get a better notion of what's happening and will the fixes that we're talking about work. So I appreciate your comments very much. Now, the 2 cases that I took a little dive into, and I'm very glad that Kathy is here today because without her permission, I shared her op-ed. But Wyndham and Windsor Housing Trust. This is another, this is the horror story case, right? And so they started out with a zoning permit. The DRB processed it in 61 days. It got to the environmental division and it took 329 days to be processed there. It then went up to the Supreme Court. It took 142 days. This is only for the zoning permit. So we're talking 582 days just for a zoning permit. Then there was the Act 250 jurisdictional opinion that said there's no jurisdiction for Act 250. You don't need a permit from us. That was appealed. The decision was made in 33 days. Appealed to the environmental division, 143 days processing. Supreme Court, 247 days for a total of over 600. Kathy has a lovely opinion that rings the alarm bell and says, how can this happen? Lindsay Curley, the same. This is a problem for our housing. And it is. Sure, it shouldn't take this long, right? Looking into these cases, there was motion practice. There was an interlocutory appeal, attempt to go to the Supreme Court, early on a preliminary issue. They were denied. But there is a lot of time that is consumed in these processes. The other thing, of course, is in litigation, you have discovery and you have motion practice. Much more significant than what could be created under the Administrative Procedures Act. For example, the PUC, you serve discovery and the scheduling order says it gets answered 1 week later, not 30 days. And then when you don't answer it, the lawyers have to talk and they have to prove that they sent some emails that said, please make sure that you give me your answers. And then if they don't answer that, then they file a motion to compel with the court. That's what happens in court. The PUC, that doesn't happen. If somebody doesn't get their answers in 1 week, they don't ask for an extension. They don't get to put answers in. And they don't get to put it into evidence at the hearing. So you have more flexibility in that regard. And that's one of the things that we were trying to focus on.
I have a question.
Name, please.
Excuse me?
Name, please.
Samantha, the LCP. In this case, what was the outcome? Was there new or substantial permit conditions? Was the permit upheld?
Yes.
Was there any sort of redirection or change in policy or regulation as an outcome as recommended by the court?
That's
So 602 days for the same would be upheld.
That's correct.
Thank you.
Well, just a point of information question, this is Ed Stanek. Do these two, processing times, coincide or are they in sequence?
They were serial. They were serial. That was one of the real problems with it. But, you know, often there's no reason to go to the second permitting authority if you're not gonna get past the first. So the other one we looked at is in reg wheeling parcel Act 50 determination, which is a recent case. There was no, I checked with South Burlington, there was no appeal of the zoning permit in this case. But that didn't much matter because the Act 250 process took over 1,300 days. And as you can see, I mean, this was, you know, it's a complicated project. But the information went in, it took 211 days for the processing. I think it went in like November, and then by July or something, they issued it, if my memory is correct. It may not be. And then there was a motion to alter. Oh, wait a minute, you made the wrong decision, we want to change something. Okay, so that took only 21 days when it was asked for. And then it went to the environmental division, 700 days. Now, this is not to highlight anything. I mean, our environmental judges work tirelessly, but we have a system that allows a lot of time to be consumed with motion practice and demands underlying, but that motion practice is the demands on due process.
Question. The Samantha question, repeated with this one.
Yeah, I also would like to repeat my question.
Yeah, I'm just asking the question she asked.
Is there one?
Was there a resulting change in any way as a result of this?
No, it's really, out there, excuse me. So sorry about that. No, it was that's all. Yeah, there was. So that was to try to give some context to really what are these processing times that we're looking at? What is taking so long? And I have given you the links to the decisions because that's really the heart of the matter. You can see what was appealed, what the statement of question was before the environmental division. When you go up on appeal, file a document that's called statement of questions. And that is the appellant saying, these are the questions I want the appellate body to answer. And it's de novo in Act 250 and in most zoning contexts, towns. And so that reading those decisions will give you the information that you're looking for to some extent. I mean, obviously, you know, all right, this was a challenge and this is what the court decided and why. So, you know, if you want to do a deeper dive, the information is there and you can read it. But I did not put all of the motion decisions and, you know, there were some challenges to, you know, in one case, it was like, no one has standing on criterion 10, throw that out. And, you know, some time was consumed deciding whether it was in or out and it stayed in. So I want to stop talking now because I would love to,
Can I ask a quick question, Brooke?
Yeah,
Just
Billy?
before you,
Yeah.
I'm a little concerned that you're using some extreme outliers as the basis for this conversation that should be looking at the more common occurrence cases, like I would much rather be looking at averages than exceptions. Making policy around exceptions is a horrible idea. So I want to make sure that that's not what's driving this conversation, that we're looking at the full breadth of cases and experiences through the current system. So I just want to leave that out there before we moved on.
Oh, yeah, I'm not, because this study wants us to focus on housing, and these are cases that people are very concerned about. How could this happen in this case? I'm not suggesting that, wow, first of all, I'm not sure how much of an outlier these are. The second one I think is. But there are so few cases that have gone up on appeal that are the priority housing projects, for example. I'm just trying to look at that housing issue, give some information about it, because this is what people want solved. And certainly, I don't think that you can solve the NIMBY problem. You will always have that present, I believe, in whatever process that you choose. Billy, I totally appreciate that point, and we're not trying to suggest this is the typical case, but these are two cases, and they're the two big ones that went to the Supreme Court on the housing projects. So that's why I chose them to look at, because that's what I thought folks were most concerned about. Ron?
Yeah, I just wanted to provide some broader context for the appeal question. If it goes beyond processing times or records or things like that, which is agencies like the LERB or the PUC or similar federal agencies like the Securities and Exchange Commission or the Federal Energy Regulatory Commission, they implement and administer their mandates largely through issuing decisions. And the LERB has a mandate, and with tiers, you've got a mandate to increase housing stock and develop efficiencies and things like that. And so how you can best implement those mandates and what you need to do to implement those mandates, I think that's part of the context of what appeal mechanism should be, would be that. Not just processing time, that's of course important, but your ability to implement the new mandates and to continue implementing the Act 50 is also critical. And I think that's important to keep in mind as we debate this.
Right. And the LERB has a whole laundry list of tasks right now, the tier work and the study work. Absolutely, and implementing all of the regional plans and all of that. So no, I totally appreciate that. Really important point.
Thanks, Elizabeth Bridgewater. I appreciate not wanting to make policy with an extreme case, and I'm not sure this is, because I don't know what the larger context is, but I do think it is good to look at what can happen in a system, even if that consequence is the extreme consequence. Because if you're looking at what the limitations are of the system or what the worst case scenarios are, and that's what we're trying to fix, to tighten up and amend so that we can move quicker, then I do think there is utility in looking at things that go to the edges of the extremes. So I feel comfortable with looking at these two cases as examples of what can happen in this current system. And the consequences are significant. So and I think Kathy probably wrote it in her op-ed, but during that period of time where we were waiting to get to a decision, which was exactly what we asked for, 3.5 years earlier, the price tag went up $5 million. There were a lot of reasons for that. They weren't all waiting, but there was a lot of shifting cost implications in the environment during that period of time. And, that money could have been used to create other housing. So it's important, I think, to look at cases, even if they are outliers.
Yeah, and the other reason why I thought it was important to look at these cases was that we have heard a lot of comments about that are anecdotal that we cannot quantify, like housing developers are having to negotiate down the number of units that they're applying for. Otherwise, they're not going to be able to get the neighbors on board, and they're going to be dragged through this kind of appeal system, because since these have gotten so much press and people are so concerned and upset about them, that anecdotal information about, oh, we do everything we can, or we don't do the development. That was the other reason that people were giving for developers, just like, no, we don't want anything to do with that, because look at what happened, in Putnam, that kind of thing. And this is what happened.
So there's a couple questions on.
Yeah, I was just online.
Sorry, yes, if you could give Peter, the floor first.
Yes, Peter's please.
Yeah, I can't speak to the Wheeler case, but in the Putney case, I don't really view that as an extreme example anyway. It was an appellant that filed pro se originally, and then had a property attorney, not even a land use attorney, but they didn't abuse the legal process. They didn't really. They followed the prescribed path, and it took that long, anyway. It wasn't there was nothing extreme about the appeal itself. It followed a very typical path. So, I don't think viewing that as an extreme example is reasonable. I think it's a pretty normal example. The fact that they happened, in series as opposed to in parallel was a little added time to it. But in general, everything moved along as it should, as it typically does in the court system.
Again, this is Billy. I'm not suggesting we shouldn't be looking at these examples. My point was more that we should be looking at the full breadth of experience and not just catering a solution to things that might be on the margins. Thanks.
Thanks, Billy, appreciate that.
Sorry, Annette.
I'm sorry, Annette.
Yeah, I just wanted to follow up on the last two comments. I kind of agree with Billy. I did take a look at the Putney case, and it reminded me of what we're seeing going on in Bennington over 10 years of litigation. There are some attorneys and parties who choose to litigate, and how do you make it stop? It's something that is a problem when lawyers decide that and their clients can pay to litigate as long as they possibly can. So I don't know. I do consider these in some ways outliers, but there is a problem, I think, in Vermont with some attorneys and their clients choosing to litigate to death. So that's what I see, and I wish there was a way to make things stop sometimes, but that's not happening.
Yeah, I just wanted to share that while sitting here, I looked up the location of the Wheeler parcel. And I believe it is within the TIP and within the form-based code district, which is called the Center City District of South Burlington. It is curious to me that there was no municipal appeals process. That certainly may have been why.
Yeah.
I don't know the timing of the acquisition of that permit, if the form-based code was in place or applied to that project. But I think it's a really useful example for that reason, because certainly from the municipal perspective, what is frustrating and problematic about both the volume and the length of time it takes to get to a resolution on an Act 250 appeal, which is a state regulation, is that behind that is years of required public process to develop local land use regulation, years of local process to permit and make legal a project that is desired by the majority of the community and explicitly done so through their local bylaw and through their municipal planning and visioning documents. And then at the end, you have to navigate a 1,000-day appeal process, which ultimately upholds the permit and allows the project as it was envisioned by a community to move forward. So from our perspective, that's the problem we're trying to solve for, like that a person or a group of interveners can effectively derail or stop the housing, commerce, industry, public facilities that a whole community desires, plans for, and makes legal at the local level. And is paying for. I mean, that was an affordable housing project as well. So there's a whole nother state process that created the programs released the funding, collected the tax money, delivered it to an affordable housing project in order to answer a need of the state.
Chris?
Yeah, I was, thank you. I was going to keep quiet, but I was counsel for the applicant in the Wheeler parcel case. So it was quite a process, and frankly, it is an example that I give to people about how the process can defeat projects without regard for the merits of the project. And there are times where the process, and frankly, attorneys are obliged to be zealous advocates for their client, and they are duty bound, I think, to do what they can to advance their client's interests. And if the system provides them with legitimate avenues to invoke various procedures, they can do so, whether in good faith or bad faith. And the effect will be to delay the project, even if none of the efforts by the opponents are ultimately successful. And that is always going to be the trick with the permit appeal process, is since we don't have a crystal ball that lets us divine the genuine intentions of parties and the merits before they're litigated, we're left with a process where it is quite possible, and the Wheeler parcel case is the latest example, to severely impact a project merely by invoking the processes that the law makes available to opponents. Not by doing something inappropriate, but by simply, because every time a request is filed, every time a motion is filed, every time there's a motion to reconsider, every time discovery is issued, every one of those steps you can respond to as aggressively as you like, but you got 15 days to respond, and then they get 15 days to respond, and now it's going to be put in the hopper for somebody to decide, and eventually gets decided, and meanwhile nothing is happening. So and there is pending right now a motion for re-argument in that case, and which is consistent with how that matter has been pursued. In that particular case, you have a licensed attorney who doesn't practice in the area of permitting, who is one of the appellants. He's acting in a pro se capacity and is not acting as attorney for the other appellants, but they nod and say, "Me too," to everything that he submits. So it's, he's an attorney. He understands process and procedure, doesn't really understand Act 250 all that well, but he invokes every possible thing that he can along the way. And that ultimately, the opportunity to do that is what is the biggest issue, I think, with reforming the permit appeal process, because frankly, it is the prospect of that happening which defeats many projects before they even get off the drawing room board.
Thank you, Chris. Appreciate it. Ed?
I just wanted to briefly renew an observation I made at the first meeting, and what has been missing for years, literally, in this discussion about appeals is the role of the judiciary in the process in 2005 when the appeals went to the court. And by that, I mean the relevant legislative committees have never really explored, I'm talking here about the judiciary committees, the inability of the Environmental Division Superior Court to manage its own docket. It's atrocious that it took 700 days to go through the process. Why hasn't there been inquiry on that angle, looking at the judicial system itself, managing the docket? The second comment is, this abusive process by overzealous clients, well, there's a remedy for that in terms of the disciplinary provisions of the Bar Association itself, the Supreme Court. But the real world is counsel are very reluctant to turn in brother or sister counsel. So the abusive process has gone on in the state for decades. with the abuse of the process. So I just wanted to interject that, that there's more than just Act 250 systematically being the problem here. We have had now the experience of the appeals going to the court system for 2 decades, and they can't manage their own docket.
So, stop sharing.
If I may briefly in response to that, though, I would like to point out that the judges are bound by the rules and the statutes that govern practice before their courts. And if an individual judge wishes to, manage things more aggressively than the rules allow, all that's going to do is create an appeal issue and a potential reversal, and then we get to go through the whole thing again. So it really is, I think, if you give explicit tools to judges to manage their docket, and you are specific in what the scope of the rights are of parties in that process, I think you're going to enable the judges to do a more effective job of controlling their docket, because right now the rules and the statutes that govern their conduct limit what they can do to control docket.
As Judge Walsh has testified to the judiciary, to the legislature, there's always going to be that wall of due process that you run up against. So, yeah, we have constitutional protections, and the court must serve those interests because they're paramount. Thomas.
Thomas Weiss, getting back to Ed Stanik's comment, I've done some research on the 2 periods of time when there was the ability to appeal from to either the environmental board or to the courts. One was from the middle of 1973 until early in 1985. And the other was a pilot project on the record appeals from 2001 through 2004. In the first one, there were some 300 or 400 appeals to the environmental board, of which 39 were removed from the board and sent and went to the courts. So that's about 10%. And the other one, the pilot project, it was all set up, and over the 3 years, nobody took up the opportunity to do an on the record appeal. So the point I'm making is perhaps not quite in agreement with Brooks. Let's not get into court versus board, but that twice people have voted with their decisions to do board appeals rather than court appeals.
What's the time frame again for that, Thomas?
1973, middle of the year through early in 1985 was the first one, when it was just the applicant could appeal to either the board or the different.
So they had a choice.
They had a choice. And about 10% went to the court, and I've not tracked down court cases to figure out, to answer some of the other questions. Was there a similarity or something in the ones that went to the court? As opposed to what's the same?
It was the applicant's choice
The
or
applicant's choice,
so
only the
only
applicant's choice.
well, the applicant too.
The applicant had the choice. Parties were not allowed to make that choice.
So, what is the group's pleasure? I was expecting we might look at the models, ask each of the authors to sort of introduce them and discuss them, summarize them for us. Would you like to take a break before we begin that? We're going to take one around 2:30. I'm getting some nods.
Brooke, I was just gonna say, Chris Ray did have his hand up, so I don't know if he's taking it down because we might be taking a break, but just before you.
Oh, I'm sorry. Chris, do you have something you want to add before we take the break? Why don't we take, let's see, it's 2:16. Why don't we reconvene right at 2:30? Take a 15-minute break? Great, thanks.
we need to go. Bridges your money.
All right, we back on? Great. Ready to go?
Is it in the mountain?
Yeah, exactly. Yeah.
Mm.
I just don't know what there is to decide. Just not creative. Maybe not a lot.
All right, yeah, I guess to the right spot. All right. Liam Murphy, are you still with us? Hopefully. You still online? Maybe so. All right, what I'd like to do is move through the proposed models that have been suggested by our various stakeholders. Liam, if you're here, you can jump in if you can hear me. But what I'd like to do is just go over his models first. They were kind enough at MSK to put together the current court process, environmental division appeals. And he also added civil division of the Superior Court because our trial court system in the Superior Court has different divisions. It's civil, we have criminal division and probate, and then we have the environmental division. And so he starts at the top, of course, with the Supreme Court, and on the right-hand side is the environmental division, which shows all of the different appeals that go to them presently, Act 250 and agency enforcement matters. We have municipal panels, zoning. And what he has pointed out and others have is the environmental division was given some expanded jurisdiction to address and real estate issues that are necessary in terms of being related to the permitting. So I think those things, I've not encountered it myself, but I think those are like rights of ways or boundary issues that are material in some respect to the permitting of a particular project. And then you have the Act 250 Commission decisions, which is different than enforcement. These are the actual permits. You have our jurisdictional determinations by our district coordinators, whether or not Act 250 jurisdiction applies and you need a permit or not. And then agency permits are the Agency of Natural Resources. And there's a heck of a long list of them. On the left-hand side of his model, he lists the civil division, Superior Court, and among their many, many other matters and jurisdiction that they have over contracts and tort actions and that. They have real estate issues, boundary disputes, easements, rights of way, and also trespass and nuisance. Those are tort actions where your neighbor is a pig farm. I think it's the big one in Vermont, the pig farm that became a nuisance to the neighbors. Also agency rulemaking. And Liam, I'm going to say again, if you're with us, jump in. Oh, there he is. Okay. So Liam, I was
Yes, I'm
trying
here.
to go over. Great.
So this just shows what is the current situation. The only real change has been this very, very recent decision in a case called Ramey Dairy Farm, in which the Supreme Court expanded the jurisdiction of the environmental court. Environmental court always used to take the position that it does not have the authority to make any determination about real estate issues. In this case, there was a question whether there was required frontage on a public road. The court said that the court then had the jurisdiction to determine whether there was a public road because it was necessary to make that determination in order to make a determination of the frontage, and that they basically said where there are questions of private property rights, that is what the statutes require, and if they arise under this chapter, then it's within the environmental jurisdiction. There's still a lot of law to be determined on that. We're very early in the process. There's a lot of questions that have raised as a result of this decision. But up until now, at least, when you had case where somebody said, well, you don't have an easement or you don't have that much acreage because I have a boundary dispute with you, then you had to go to civil division first, get that decided, and then put your appeal on hold and go to the environmental division. This new decision will obviously lessen that, but we don't know the outlines of it. And it's also gotten complicated because these decisions that are being appealed on the municipal panel are de novo appeals. That is, that the court is sitting as if it were the development review board and making the decision and hearing all the evidence again. And this raises the question then, if the environmental division has that authority to make a decision on easements and rights of ways and that are necessary to make a decision on a permit, does the underlying development review board have that? And if that happens, life is going to get a lot more complicated down on the municipal level. But this was purely intended to show what is occurring today. And then the next model, which is my suggested model, is that we do give all authority to the environmental division. We give the environmental division an extra judge and some extra clerks, and I'll discuss in a minute maybe some procedural changes. But my reasoning for this is a couple of things. First of all, there is, as we have discovered, only at most 20% of the cases are Act 250 cases. Most of the cases that come into the court are not Act 250 cases. And in addition, even in those Act 250 cases, there were only, I think, 6 pending cases in the last 2 years that involved housing, and only 1 that involved a priority housing project. Yes, there are some really bad examples of what have happened, and I think those can be resolved by procedural changes in the court, how the courts handle the cases. But I don't think we should throw the entire system that has been established with precedence over the last 20 years as a combined court, and obviously much longer under the zoning matters, in order to deal with a few housing cases or a very small minority of Act 250 cases. I really do think that if proposals to move away from the court system is having the tail wag the dog. There are a couple of reasons that's important to be in a court. One is due process reasons. I do represent developers, but I also represent municipalities, and I represent opponents to developments over the years. And I think the court system is the best place to assure that they have due process. Secondly, I do not believe that the land use board should be given jurisdiction to interpret the laws and the regulations and the application of its rules that it has created. The land use board is going to be the one that oversees the district commissions. They're going to want to write the rules. We shouldn't have a situation where the same board that is writing the rules and review and overseeing the first level of review of those reviews then turns around and gets to interpret its own position. I think I think there's a real inherent conflict there, and I think that removes having an independent court look at the rules and interpret them as they are written, not necessarily how a board would write them. Finally, I just would say that I do not believe we should be trying to change the entire system just to resolve the time issue. There are ways to do that. My suggestion would be something, I know that there's been in some legislation some saying they got to make a decision in 3 months. Well, that's impossible. It's not realistic. But a calendar that would say that in the court system, all discovery has to be done within 3 months. Mediation has to be completed within 6 months. A trial has to be completed within 9 months, and a decision that has to be issued within 12 months. Assuming that the court system got an additional judge and additional clerks, I think something like that is a better way to try to resolve the problem. I think that one of the things I've learned in doing this for 40 years is that for owners of property, developers of properties, municipalities, and even those opposing development, having a system that has predictability is a very important issue, because people want to be able to make a determination up front whether to make an investment in their property based upon a predictable outcome. And I think if we totally overturn the entire system and go to an administrative law judge system, or having everything come to, these 80% of the cases that that are not Act 250 come to the land use board to be decided with hearing officers, we're going to have a situation where for a decade, the interpretations are going to be unpredictable. And I think that will lead to an unintended result, that there'll be less development. So I think we should stick with our current system. I think we should, in effect, make the environmental division an environmental division and land court. We should fund it better, give it an additional judge and additional help, and give it rules to follow in order to process cases quickly. So that's my pitch for my proposal.
Thank you, Liam. Can I ask you a question? You mentioned inconsistency if it were to switch to a board. Now, in the past, we had the environmental board and e-notes that were kept up and so comprehensive. As a practitioner, it was such a convenient body of law to be able to access that seemed to provide that kind of consistency. Can you comment on that versus precedent now as it develops at the environmental division?
Well, there's two types of consistency that goes on. That if you have a bifurcated system, as you used to have, you could end up with, and I had ended up in cases where what was decided for what was approvable under the municipal approval was different than what was approvable under Act 250, and it caused conflicts there. If you're talking about consistency of prior decisions, when the environmental court inherited the jurisdiction over Act 250, the legislation indicated that it did have to give precedential value to the prior decisions of the Environmental Board, and it has continued to do that. But we've now had 20 years of consistent judges. I mean, we just had one judge change after almost 20 years. And I think the judges cooperate, and I think that there has been very little inconsistency in the judge's decisions. And what I would be concerned about is that if you end up with the decisions being made now by an entirely different group of people, either the land use board or hearing officers on the last bureau board or an administrative law judge, then we're going to have a whole new set of interpretations of past histories, particularly if we shift, as has been proposed in one proposal, to shift zoning appeals to the land use board. That I think would end up creating an enormous insecurity in how people can plan in the future because they won't know what the consistent interpretations would be.
And while I have you on the on the hot seat, do you have an opinion though about, I hear your argument on consistency with, you know, one or two judges deciding, but what about the notion that I've heard raised by a lot of our stakeholders that a group of 5 people with various expertise coming together and making a decision is a better, more informed process and decision-making result as opposed to one single person? Do you have any thoughts about that concern?
Well, yes, I do, but I'm a lawyer, right? And I've always taken the position that that the legislature writes the laws, the regulatory agency writes rules interpreting that law, and therefore those provide the guidance to what the applicants or opponents to applicants are bound by that law, and that it should not be looking at a piece of at a law or a regulation. Once it's written and established, it then shouldn't be a policy judgment of whether this is the proposal is beneficial or not beneficial, or is something that we like or we dislike. It should be, does it comply with the written law or the written regulations? And the concern is, frankly, from my standpoint, that if you have if you don't have a judge making that determination, but you have non-judicial actors making that determination, then those policy issues of whether it's beneficial from their point of view or they don't like it from a different point of view tend to come into the conversation where they don't belong. Once the rules are written, then people are entitled to whether until the rule is changed, they're entitled to proceed under that rule. And I get very concerned about a lay board making legal decisions about compliance, because I think what happened, and I do think it happened under the environmental board's view, is that many of the decisions were made by the board as to what it would like its outcome to be, not necessarily what the then current rule or regulation was.
Thank you. Appreciate your response.
Brooke, I have a follow-up. Sure. I'm curious about this line of questioning about the sort of expertise necessary. I agree. I've heard that argument made in favor of a board for hearing appeals, that the professional skills of the board would be a benefit. My question is to the stakeholder group. Is there a complaint that the outcomes of court decisions on appeals have been problematic because of a lack of that ability? Like, is that a problem that exists we're solving for with a professional board? Or is that not a problem that exists? Is that contained in the sort of list of complaints on the current court system as it's been in place?
Ron, questions?
There are a number of quasi judicial agencies, both on the federal level and the state level. You see, an example that you're supposed to be familiar with.
Can you keep your voice up for the microphones?
The PUC is probably the most common example. They're a labor board, they're not all lawyers, they have staff. They promulgate rules that they implement and they enforce. The entire, maybe I'm missing something, but the entire administrative system, when you have a commission or board, which is the chunk of the agencies, state and federal levels, work in a way where they promulgate rules and they're not judges, they're lawyers, they issue decisions.
Yeah, the PUC, right now, the chair is a lawyer, though it's not statutorily required, and Tony Royston, the predecessor, was as well, and I think both states were. So in that particular setting at the PUC, it's not required, but one of the people is not a layperson, they are, or had been. Yeah, John?
And I like to echo, I think, one response to that question that Ron said earlier about agencies basically managing programs through decisions that they get to make. And one of the reasons that what Liam is talking about, one thing that I think is missing from his analysis is that Vermont is an outlier, that these are de novo decisions. So basically in Vermont, I don't know there's any other state in the country where, just take Act 250, basically the permit is being reviewed by the court as if they're the permit issuer. They're not just making a legal decision. They're not just making a decision about whether the process was filed. They're determining, writing a decision about whether a permit is required on the issues appealed under Act 250 or zoning, and crafting conditions. And that's not what courts do in the country. Courts look at records and they decide whether or not there's evidence in the record to support a decision. They decide whether the law was followed. And so that is what's missing. Is I think it is more, I think there is something missing to your question from the current process where we don't have professionals in land use. Basically, what should the condition, we're going to ask them to do a de novo to make decisions about, it's not just like, is this the interpretation of the law right? Did they follow the process right? It's like, what should the condition be? What should the condition be to make sure that the project in Act 250 meets the 10 criteria, whatever the criteria that are appealed? So there are just inherent decisions about like permit issuance that courts can't do. So I think that's what's lacking because they're judges, they're not land use, they're not an administrative agency of land use professionals. Now, if it was a record review, I think having the court, do what courts do, would be completely appropriate, and there wouldn't be an issue as long as somewhere in the chain you're getting a decision on the permit issuance. And so I think what's happened, since 2004, we basically asked courts to basically issue permits and not just make legal decisions. And so that's just some disagreement that Liam and I have. I don't see it as inappropriate for a board to look at how its rules or the statute work. I think they're basically in our de novo system making a permit decision, and that is better done by land use professionals in an administrative setting.
I also want to follow up on, picking up on what John's saying and following up on Liam's comments about consistency. The environmental division's decisions, like the old environmental board decisions, would still be precedent, I would imagine. But there's been a change in the law. And so who's going to get first crack at implementing the change in the law? If the LURB is doing it the way other agencies do it by issuing decisions, that's much more efficient. So we have to wait the halting process of one board waiting for a decision, and then that's how to implement. When the court's not charged with implementing a program, it's not charged. The court can't be charged with a mandate of increasing housing stock or turning around decisions on development more quickly and more economically. That the implementation of changes will be much more rapid and if implemented by the agency that's supposed to implement the mandate.
Sorry, Chris has.
Sure, Chris?
Yeah, and Vermont, as we are all aware, is a unique little corner of the world. And we have a lot of very small communities that take the lead in their local permitting. And it is our dedication to that model that creates part of the problem, because the town of Athens, Vermont is not going to have the resources to run an appropriate evidentiary hearing to support on the record review. In addition, one of the benefits of having a court conduct a de novo review in Vermont is it brings a degree of objectivity and consistency to the case that isn't necessarily going to be there, especially in small communities, but in all communities across Vermont, where friends and neighbors are looking across tables at each other. And it's not fair or realistic to expect, a somebody who's, serving as a volunteer in his local DRB as a favor to his community, when presented with the, pitchforks and torches, to rise above it all and conduct a fair hearing under adverse conditions. So we have this quirky local control. We don't have county government. We don't have a more consolidated permit process that would allow, let's say we had 5 permitting districts in the entire state, and every zoning hearing was conducted in one of those 5 districts. Well, you're then going to be able to have the resources and expertise to run a true, fair hearing. And that's just not what we have. So the system that they came up with is, let's do a de novo review. The Supreme Court has made it clear that the de novo nature of the review eliminates, for the most part, any concerns that people have regarding how they were treated in front of the local board, because de novo wipes the slate clean. And so any prejudice from that is gone. So there's real difficulty in trying to expect too much of our local boards, which isn't to say they're incapable or don't have the personal ability to do it. It's just they don't have the resources or the time, and the system's not set up to support them in that function. When you get to a court and the benefits, and Liam was mentioning this, of who should be reviewing these legal issues, I was on the environmental board, and I happen to be a lawyer. Most were not. And then there were staff attorneys. And for good or bad, and any of us who have served on any board know that there is inevitably, if you're a part-time or less than full-time staff person, and even if you are, you're going to defer and rely upon staff advice. And so what you have is non-legal decisions being informed by legal staff. And I can remember conversations back when I was on the board where people wanted to reach one decision, but they said the lawyer says we can't do that. And I'm like, well, no, that one lawyer says you can't do that. That doesn't mean you can't do it. And it becomes less transparent, I think. So there are real benefits to the system that we have now. I think, as I mentioned before, the biggest problem is ultimately coming up with a process that is predictable and timely, and then making sure that people with the right resources and the right expertise are making the right decisions along the way.
Thank you so
And
much.
one other
Chris.
thing I wanna mention before it gets lost, because I know there's gonna be a lot of people talking. I wanna let people know that there is also not, um, there are not resources to do more DRB transcripts. In case people aren't aware of it, eScribers, which is the contractor that handles court transcripts in the state, has recently said that they're not going to do transcripts of live DRB hearings after the fact anymore. It was too difficult. The quality of the recordings is too poor. They can't hear what people are saying. And as a consequence, they're just not able to create a transcript that's acceptable to them. So even I can tell you right now, and we only have what it is, 10, 12 communities that have on the record zoning appeals right now, it is virtually impossible to find a transcriber who will transcribe a hearing. And it's one thing if it's a simple hearing, it's one evening, and there's only a few people involved. But if it's a significant project with significant community interest, where you've got lots of people in the room and stuff being thrown out there, and you got some people online, some people in person, people submitting exhibits, it's just, frankly, the current system isn't sustainable. And I know that the town of Stowe is evaluating whether to go back to the traditional process because of their very bad experiences recently with on the record review. So I just wanted that factoid to get out there and inform the discussion if it comes up.
Thank you, Chris. Representative Mahali?
I have a question for the group, I guess. The usual administrative model involves one agency, such as the PUC, the Labor Board, FERC, you name it. One agency makes the rules, and they have a rulemaking staff, and they also do the adjudication. And the practitioner who practices before them has both. The LURB, under the system proposed here, this is a divided system. The LURB would be making rules and someone else, the judiciary, would be interpreting. Is there any other example of such a divided system?
Well,
Is there?
don't PUC decisions get appealed to the court?
To the Supreme Court, sure. Yes, on the record, to the Supreme Court. But the PUC makes its policy both through its rulemaking function and by making rate decisions.
We're citing decisions for projects.
I'm asking simply, are there other examples of such a divided system?
Are you talking about, because we also have commissions that are part of our organization that are adjudicating cases and applying the rules. So I'm not sure if I heard if the distinction you're making is between with the court interpreting our rules. That would just be on the appeals of commission and other district decisions. So we do have that layer of administrative decision making.
That's Allison Stone.
So that she's referring to the local commission, right?
The Act 250 district commissions.
Their decisions are appealed to the court.
Right.
So it's divided. Now, I understand that. I'm asking, is there any other system that anyone knows of that is divided in this way?
I guess I was pushing back a little bit on it being divided because our organization is setting rules and then we are applying them in the context of our commissions making decisions. But I guess you can make that distinction between the commissions are not the ones promulgating the rules, but we are all one organization. So, but I think
that Mark is talking about is at the the de novo appeal system we have in that the court, which is a completely separate entity implementing and interpreting the rules. Not the district. District commission is part of the system. It's part of the same system. It's as if, FERC made rules and then they never got a chance to apply them or interpret them in a permit. They would just go right to a court, to federal district court, I guess, de novo.
I mean, that's how appeals of property evaluation are managed. The lister.
There's a really easy resolution of this issue. Just like, why don't, if this is, John, if this is the major concern with the current process from your and others' perspective, that the de novo approach is not appropriate, then just do majors on the record. There's less than a dozen a year. Almost in every major case, attorneys are representing the applicant, if not the interveners. Just do those on the record. Then this disappears and cases go on the record up, right? That's a simple fix. Instead of upending the entire system we have right now, just do majors on the record, and it solves for this problem.
Also, taking a second, Brooke, I know at one point you had, when you queued up the models, you had said, we're not necessarily going back to the debate of court versus board, but you wanted to like get into the specifics of some of the models. And so just wanted to come back to that. Up to you how you want to proceed with the last 50 minutes, but.
Thank you, Allison. I appreciate that, but I want to make sure everyone who has their hands up has an opportunity, but some hands have gone down and I see only Annette's.
Yeah, I guess I have 2 points. One is that the PUC rules do go to the legislature for approval, but I've been trying to think of a response to Representative Mahaley's question, and I can't think of one. Responding to what Billy Coster said, no, that does not solve the problem for the public. So I'm sitting here in this group thinking through all of these things as a sort of the voice for the people who are not represented by lawyers, who do not have the skills or the money to hire lawyers for an on-the-record case of majors at the beginning. There is great value to district commission processes, and unless there is intervener funding or something else, I don't see that the proposal that Billy just made does address the public interest. Thank you.
Jim, Juma?
Thank you. I want to preface my comments by saying I have never been on the same side of a case with Chris Roy. He and I have always been on the opposite side, but I have to say he's right. I agree with everything Chris just said, except for his conclusion that this should be judges, not a board. My conclusion, based on everything Chris has said and my own experience, is that with zoning boards, there must be de novo review. Whether it's in front of a board or it's in front of a court is less important. For all the reasons Chris said, there cannot be on the record review of zoning board decisions. Thanks.
And don't let it get out that Jim and I agreed on anything. That's not going to help either of us.
I believe this is being live.
I don't know, we can maybe hide this somewhere. All right, thanks so much. I'm going to take Allison's suggestion, and because I think we've gotten a little bit afield. I mean, these are important issues, but I did want to be sure that we gave the opportunity to see all the board models. I'm going to go ahead and summarize this to say, so the MSK proposed model that they think is the best is to enhance or add to the jurisdiction of the environmental division for that agency rulemaking and the real estate issues, all the big enchilada, all of those boundary disputes and tort actions, etc. Very interesting idea. And then they also suggested one possible thing to do was to have the Act 250 cases, the JOs, the jurisdictional opinions, and the commission decisions to go up to the Land Use Review Board as a quasi-judicial appellate board. And then that decision would be appealed to the Supreme Court. the same way the Public Utility Commission decisions go directly to the Supreme Court on an abuse of discretion basis. That, many people believe reduces the number of appeals to the Supreme Court. Liam?
Can I just make a comment that this was not our proposal? This was prepared, these three charts were actually prepared for a legislative committee to review different options. And this board appeal model, number one, was one that was being proposed by, I think, one of the bills in the legislature. I don't support this. I just want to make sure that you understand that it wasn't a proposal by us. It was just an illustration of one of the proposals. But other people may support it, but I just diagrammed it.
Gotcha. Oh, thank you so much for clarifying, man. Appreciate it. And then, so let's move on to board model number 2 so that I can take a little rest and you can stop listening to me. I would like David Mears to summarize, introduce, talk about, tell us about your idea.
Yeah, thanks, Brooke. And it's not my idea. You know, this conversation has been cooking since I first arrived in Vermont in 2005. And we repeated a lot of it today and over the course of the last few meetings, the same kinds of discussion and debate that's happened. I do think that what's changed in recent years, and illustrated by some of the housing examples, is that it's not working. And I think everyone agrees with that, with the possible exception of a handful of folks. If you agree that it's not working, then we need to change something. And it could be that we could improve the court system. I haven't yet seen a proposal to improve the court system in ways that make it more efficient. I think just putting deadlines on it, saying that nobody, limiting the number of people that can go to court, those may have some help, but I think we have to deal with some systemic issues if we want to fix the court system, which are going to discovery and, the standard and scope of review. And just a quick administrative law professor, diversion, scope of review, meaning we tend to, when we talk about de novo, we mix it all up together, but scope of review meaning what is the court looking at? What's the record? Is it a brand new record or is it a record was created somewhere else below? Standard of review is kind of what's the legal standard by which a court looks at it? Is it an abuse of discretion? Is it discretion? Is it deferential? Is it, de novo? So we have to look at those issues if we're going to fix the court system. So I'm open to improving the court system, but this recommendation that I think reflects conversations I've had with lots of players, particularly in the public sector, because I think the folks that are in the public sector tend to think not just about efficiency, but about the broader set of criteria. Are we effectively implementing the laws that we've been asked to implement? Do we have consistency, predictability, fairness, accessibility to the process? There's a broader set of issues than just being quick and efficient and timely in decisions. There's a broader set of issues. And one of those is being effective. And so giving I think John's talked about this in some prior discussions. Ron's hit on it a little bit today already. But one of the criteria that leads me to feel like the LURB is the right place to be hearing adjudications of decisions under Act 250 and frankly also local land use decisions is because it's an entity that will be more effective in implementing the programmatic outcomes we're trying to achieve. It's not just asking the question, did they follow the process right? Did they apply the rules exactly right? It's asking the question, is this decision tending towards achieving the outcomes that these statutes that the legislature passed are intended, which include, protecting our land use, our communities, advancing housing, public safety. There's a whole mix of things that get embedded in these. So with that, let me talk a little bit about why I think that the Land Use Review Board is the right place to house the adjudications. I kind of touched on one of those criteria, which is the effectiveness. I think that one of the things that happens when the entity that's writing the rules also has a tool of adjudications. Those two things can interplay. If there's a consistent issue that's unresolvable in an ad hoc, way on a case-by-case decision repeatedly, and that ambiguity is causing problems for applicants and or opponents of projects, the Land Use Review Board is the best entity, having seen those cases, to resolve that through rulemaking. And vice versa, when it has adopted rules, it has the greatest sense of what went into that, the administrative technical understanding of those rules. So it's in the best place to interpret them. That doesn't mean that there isn't a court review process. You still have the Vermont Supreme Court review that can make sure it's constitutional, that it follows what the statute says, and that basic fundamental due process is followed. But it makes sense in the first instance, kind of as Professor Mahali was suggesting, that you look to that the administrative agency that wrote the rule administers it. That is that's frankly how the administrative system of law was created. It's kind of founded on that premise. Vermont is in this area is an extreme outlier. So another thing, in terms of kind of efficiency, one of the things I talked about that is a dog that I fear, the legislature is going to have to continue to watch be beaten in front of it. But the issue of record review, it tends to be flagged as record review is one thing or the other. It is a full, complete, perfect record developed at a local government level, which I agree is unlikely to happen in the state of Vermont. As long as we let local governments decide these cases, they're not going to come up with an administrative record that's perfect. I think district commissions probably could. But in any event, even if a district commission doesn't do it, there's also ways to develop a process in which an administrative law judge, a trained hearings officer, can complement, supplement, fix the record, fix the gaps, provide limited ability for parties to bring pre-filed testimony to fill gaps on criteria that weren't addressed properly below, or to explain complex issues that weren't resolved, or in the instance that the recordings are garbled and can't be transcribed, to give whoever it was that made those remarks a chance to come in and have that. But it's limited, finite, and it doesn't open the door to, endless, unlimited numbers of interrogatories, depositions, and all of that. So anyway, record review is also the norm in most administrative law proceedings across the country at the federal and state level and local level. Why we're afraid of that is confusing to me. And I don't quite agree, Chris, that it's, Vermont is so special and unique that we have to do something that nobody else does. What else did I want to say? Oh, in terms of accessibility, one of the things, the elements that I tried to include in this idea was a couple of things. One, an ombuds role that we've kind of lost it at A&R as we've lost the permit specialist, but I think all of us who work with local governments, with applicants, pro se applicants, or opponents of projects that are not as sophisticated, everyone struggles with complex regulatory process. Having tools that the LURB could have that provide some support for applicants, for opponents of projects, that can just help them walk through and understand the process. And then to have something other than a full-blown appeal. I totally 100% agree and completely respect Annette's work over the decades to make sure that the people she works with have access to the process. But access at the district commission level and access at local government isn't the same as having access all the way through the process. And there should be an opportunity for applicants or opponents of projects to appeal things that don't require them to get a lawyer. And the LURB could easily have a simplified, many agent administrative appeals offices around the country have this, a simplified appeals process that doesn't even require attorneys. Just the applicant shows up, the opponent shows up, and there's either a mediator or an ALJ that can just let them talk, have their day, develop a recommendation based on that, and the LURB decides it. There's, I think, plenty of ways to kind of give additional tools that give kind of your average person access that doesn't have the ability to hire someone, with the hourly fees that I charge. So I think accessibility is a key piece. And then, you know, so you have one set of tools are kind of a choice between simplified appeals, or we know some of these cases, you know, maybe even priority housing projects are going to be super complex. They're going to raise a range of environmental issues at A&R, a range of Act 250 issues, as well as local permitting. If they're going to be big, complex projects, let's have a complex procedure that's set out, built out for that to be resolved through that process, but it should be predictable, certain, and not open to a lot of procedural gamesmanship. And my experience has been that administrative agencies, particularly those that have responsibility for, as in this case, the LUR, for managing the decisions of the district commissions and being kind of a vetting place to make sure they're consistent and applied well, there's much less gamesmanship that happens in terms of remands back and forth between the appellate entity and the decider in the first instance. I think those are the main points that I want to make. And again, it's not that I disagree with Liam that the courts need to be involved. I absolutely fundamentally agree there needs to be an entity of last resort to make sure that there's fundamental fairness and that we don't have the LUR or local governments running afoul of state statutes. And the Vermont Supreme Court can play that role. And they can do it based on a record that's been ensured to be a quality record by the Land Use Review Board with the help of its administrative law judges. And the part that I've left off to the side, and I'll let John talk about, you know, some of his thoughts about this, but I don't think that it makes sense for the LUR to hear appeals of stormwater permits or air quality permits or the A&R permits. Those are so technical that it just doesn't, it's a completely different animal. But that doesn't mean that people shouldn't have an opportunity, a meaningful opportunity to appeal the A&R permits. I don't think that should be all to a de novo scope and standard review to the environmental court. You could have the same batch of ALJs that serve the LUR also serve A&R and create kind of an internal administrative process for them to make decisions. So I'll shut up.
Can you explain the model though? I don't understand fundamentally what you change.
Help me understand what it is that confuses you.
What body has jurisdiction of what parts of the process? When I look at this, I can't interpret that.
I'm not suggesting any changes to the jurisdiction that happens now. So local land use decisions are all the municipal decisions that are made by DRBs and zoning boards and stuff. The Act 250 district commissions decide Act 250 permit decisions. And A&R decisions are jurisdiction of Clean Water Act, Clean Air Act.
And appeals to those permits are heard universally at the, this is what I don't understand. I'm not being argumentative. I do not understand what you propose.
Local land use decisions and Act 250 decisions go to the LUR. And A&R decisions end up being decided by the secretary after, you know, there's an adjudicatory process that could happen before an ALJ. But ultimately, the secretary makes the decision and those are appealed to the Vermont Supreme Court.
Okay, so you propose that appeals to Act 250 permits are heard by the LUR.
Correct.
Appeals to A&R permits are heard by the secretary.
Correct.
And municipal permits are appealed to
The LUR.
the LUR. And in each of those cases, an appeal could be brought to the Supreme Court. An appeal of the LUR's decision.
Correct.
Or the secretary.
Or the secretary.
Always an appeal to the Supreme Court.
Okay.
Yeah, if you look at the map, if you're out, move the colors. So here's our land use decisions that district commissions will make or a district coordinator on a JO. Oh, I'm sorry, local land use. Sorry, this is the municipal zoning. I'm sorry, I didn't make pointer in the wrong place. And the Act 250 commission decisions and JOs. And what is being suggested is an administrative law judge who then makes a recommendation to the LUR. And this is copying the model of the Public Utility Commission. They have a hearing officer that conducts a trial. And in this notion, the trial has already happened below. So this is on record, you're suggesting, David?
Yes.
Okay, so the administrative law judge does an on the record appeal or fills in the gaps if the record is lacking something or people want to put in other evidence or what have you. So they then write up the decision as a recommendation to the land use review board, just like the hearing officer at the PUC conducts the trial, and then he or she makes a recommendation to the Public Utility Commission. And so the land use review board, like the Public Utility Commission, would either accept or reject or modify the recommendation of the hearing officer or ALJ person. So it's similar to how the Public Utility Commission does it. And he's suggesting that we then have the A&R decisions completely separate and they go up to the A&R secretary. They shouldn't be coming over to.
Okay, that's helpful. I have another question to David, which is, do you support this model if the board is not the LURB? Is it important to you that the administrative body of the LURB be the decider or that it be a lay board?
I mean, I'm kind of agnostic on how the legislature has defined what the LURB is. If the legislature wants to revisit that, I don't particularly care, but I do feel like there needs, the LURB is important for this reason. It goes back to the point that Ron has been making, which is that the LURB is responsible for the administration of Act 250 and all of its outcomes, whether it's housing, land use protection, a variety of things that are encompassed within Act 250. And it makes sense for the entity that's responsible for that to have as one of its tools for implementing that law, the ability to adjudicate disputes over the permits.
Just add that the proposal for decision and the review by a board is already enshrined in the Administrative Procedure Act of Vermont, so it's existing law there, and it's commonplace.
Let me just online, looks like Billy Coster had his hand up and now.
Yeah, just a couple of quick clarifying questions. So I'm pretty familiar with the PUC process, and in that instance, the PUC decision that's based on the hearing officer's proposal is the primary and initial decision in the matter, right? It's not a decision on appeal. So I'm confused by this. You're trying to relate it to that, but in this instance, it sounds like you're suggesting the LURB would be hearing an appeal of a district commission decision. With the PUC, they're hearing the case in the first instance. They just get to make the final call, and those are different things. So I'm struggling to understand that parallel. If you wanted this to be like the PUC, you would just have the hearing officer run the case with the district commission. They'd build a record, they'd make a recommendation to the LURB, and that would be the decision. And that's effectively what I was just advocating for, was doing majors on the record. So I don't think it's a direct parallel to the PUC is my only point.
Decisions be made on the record, but not by an ALJ. And I wasn't the person recommending that we use the PUC model. Brooke was, but I think Brooke was more talking about in the context of how the decision is then, decided by the LURB. But I don't think it makes sense to have an ALJ assigned to every district commission decision on an Act 250 permit. You have so much more experience than I do, Billy, but my sense is that
my point is you can only appeal majors, right? Like you can't, my understanding, and the lawyers would know better, minors can't be appealed. You need to request a hearing to reserve the right to appeal. So we're talking about, at least under the last decade, less than a dozen cases a year. So that's the whole universe of this whole study, at least from the Act 250 side, is less than usually 10 projects that go forward as majors and get appealed a year. Or maybe there's like 20 majors, half of those get appealed. So I'm just trying to narrow what we're really talking about. But thanks for that clarification, David.
Sorry, I don't mean to talk over you, Billy.
No, I just said
I
thanks for
think-
that clarification.
I think we're in agreement, because just the ALJs would just be hearing those cases that were appealed from the district commission. They wouldn't be involved in every district commission decision, working up the record.
And then just to clarify, as Brooke was saying, so they would basically be able to kind of, make any corrections to the record, right?
Yes.
The ALJ serves as sort of a quality control, because the issues we talked about before about concerns about district commission or zoning boards creating a record. It's a way to funnel it up, have somebody then kind of clean up the record, and then it can go to the LURB to review the decision, right? Okay.
Yeah, let me just respond to Billy. Billy, I'm not suggesting that it's exactly like the PUC. Yes, obviously, the PUC hearing officer is the first decision maker or recommender, maybe who makes a decision to recommend. My point was that that individual would be making a recommendation to the LURB, just like the hearing officers in the PUC make a recommendation to the commission, and the Public Utility Commission decisions are then only appealed to the Vermont Supreme Court. They do not go into the trial court system. That was the similarity that I was trying to illuminate, that it already exists in our law, and then thankfully Ron knows that it's in our APA. I was not aware of that. Thank you, Ron. Yeah, Kathy.
Yeah, I've obviously been around with this issue a long time and had lots of discussions. I'm quite attracted to this model, and I think what we've been missing is this discussion of having an administrative law judge that function, which is my understanding is most other states have this format, and for whatever reason, we've hung up on to our model. And as Chris Roy pointed out, I like this model even more for the municipal decisions, because every DRB is different, and the quality, not casting, it's just they're volunteers, and some of them have more experience than others. So I would see the administrative law judge or hearing officer played a really important role for assembling the record, or whatever you want to call it, in a way that is just going to be more. It's not going to be the way the court functions. The way the court functions by nature and is slow and does not allow for what I think this might allow for on the municipal side. So I'm quite attracted to this, and I know some very strong opinions about the court versus the LURB, but I think that administrative law judge function is a really important point.
I got hands up online and in the room, so let me go to Liam, because he's had his up for a while.
So my concerns are about these models is first about the local zoning land use decisions. Again, they really do have to be a de novo appeal. If we force the decisions on a local level to be on the record, we are going to create a situation where the public in general will be really shut out of the process, because it then will become much more legalistic at the local level. And most of the towns who have these boards don't have the ability to create that record. So that's the first issue is, again, I just repeat, I don't think we're trying to solve the problem of some Act 250 permits and housing being delayed, and to change the whole system of decisions for that doesn't make sense. Second, my experience with the Public Utilities Commission and Public Service Board has been that when the opportunity was given for telecommunications to move out of Act 250 and move into the Public Service Board, Public Utility Commission realm, they did. And one of the reasons is that it was much more difficult for the public to be involved, and they have been. It's It is a system that is much more procedural, much more difficult to get involved in, and I think the same would happen here. And I'm afraid that moving to an administrative law judge system with an on-the-record appeals would start eliminating public input into decisions. And all this was really doing is taking two environmental division judges and making them administrative law judges, but then ending up with a recommendation to the land use board to make the final decision. It really doesn't solve any of the problems that I think are causing the concerns that people have about the current system. Thanks.
Where were we?
Representative Mahali?
Question for you, David. So you were at pains to explain the two de novo. Would you fill out your model and tell us about the review levels for how it would function?
Yeah, so we've mostly been talking right now about the idea of administrative record, which relates to the scope of review. So I'm suggesting that we have a scope of review that's limited to the record developed at the district commission or at the local government level.
As supplemented if necessary.
And supplemented, again, for address complex issues or gaps and, things that were addressed below, or garbled transcripts or the like. And just as a quick aside and partial response to Liam, I don't think there's any reason that you would have a limitation on public participation in a local government DRB decision that's different from what it is now. That would just have to be captured. If they wanted it to be considered as part of their decision, on appeal, they would have to find a way to make sure it was recorded in some fashion. Either they spoke clearly, they presented written comments or the like. But the other part of the standard of review is what's the kind of the standard of review, not just the scope. So that could be deferential. I think, frankly, for instance, it's clear that the Vermont Supreme Court should be deferential to the Land Use Review Board. What's the level of deference that the Land Use Review Board gives to a local government decision or district commission is something we could play with. It could be an abuse of discretion. It could be deferential. It could be substantial evidence. There's a tier, kind of a tiering of different levels of intensity of review all the way up to de novo. I would recommend against de novo, and this for the same reasons I recommended having a de novo scope overview. It just opens up the door too wide for a revisitation, and it doesn't give some. If you're gonna give the decision-making role to the local government, that should count for something. It shouldn't be that you have to start fresh. When you go and you're the applicant, you make your case to the local government, and then you have to redo it all over again to the Land Use Review Board. That was one of the things I experienced when I was at A&R, when there were permit decisions that were appealed from A&R to the environmental court. It was hard to overcome the staff inertia around, well, what does it really matter what we decide? The environmental court's just going to redo it anyway. It creates bad incentives for opponents of the projects who have then the incentive to just sit back and wait. Like, why do we have to make a fuss? We'll just make them spend all their money, go all the way through all the permitting process, and then we'll bring up issues at the environmental court. That some of that's been addressed by efforts to kind of limit the issues that can be raised on appeal, which are good steps. But when you have de novo standard of review, you run the risk of that same kind of inertia, or frankly, of applicants feeling like, it's a crapshoot. The entire cost of this project depends on whether someone has the resources to appeal it. And if they do, I have to restart and present my whole case and all my experts and pay all my consultants all over again.
I have to say, when I came, I spent a lifetime in California practicing land use law, and then I came to Vermont and didn't think about land use law for a while. But just for the non-lawyers here, the difference between de novo review on one hand and abuse of discretion on the other is like night and day. With a de novo review, the judge just starts from scratch as if nothing had happened. They literally can just decide how they want to decide as if they were the original decision maker. With abuse of discretion, you have to show that the original decider, which in this case would be the local jurisdiction, that they acted in such a weird and bizarre way that it's just, there's no reasonable person could possibly agree with them. Or that they ignored some basic procedural rule, one or the other. And I can tell you the number of cases that I've won where I was fighting abuse, I had to show abuse of discretion. In 25 years, it was like 5. I mean, it's just very difficult. It's extremely different. And in most states, that's the standard. The local government makes a decision. That's it. The court will only go against that if it just violates common sense in the worst way. Now, I'm not saying there aren't very varieties, but I just want to put my law professor and my practitioner hat on, not my legislator. These are really different things.
Annette has had her hand up. Let me let her speak, please.
So I think I'm going to agree with Chris Roy and Leah Murphy. A number of things. The ALJ model, to me, having spent a lot of time in PUC cases, and especially recently, there's a lot of towers coming along, and the citizens that I work with will describe the process as brutal or torture. It is not in any way friendly to the public, and it looks to me from what this is proposing, if the goal is to speed things up, an ALJ is going to add time. It's not going to speed things up. I can't believe what I see go on in Vermont's municipalities. I call a lot of the things that I've witnessed the friends and family boards, and it's town after town after town. It's kind of rare that I don't encounter that. And I'm very grateful to the district commission process because that has created an ability to get away from that. And similarly, the Public Utility Commission has created a way of overcoming the friends and family that we have as the deciders on the local level. It just, if we're looking to have more efficiency and have things sped up, this model with the ALJ, I would need to understand more what that role is. But to me, it looks like adding a layer of paper pushing. And I'm dealing with people who say, when do we get to speak? And at the district commission, you do. But once you get into these court proceedings, it's a very different world. And we have to keep the public's ability to participate in mind. Thank you.
Annette.
Megan Sullivan. I'm hearing Kathy say she likes the local land use decisions going to the LURB. And I know this is also in the NRC's proposal. I have some level of worry here that if the majority of appeals are not Act 250 appeals, they're local land use appeals. Part of what I am very excited about having a professional LURB in place is to ensure that we are getting to a place of those initial decisions that coming from our commissions and our coordinators being effective, predictable, like that process. Is the LURB going to be so bogged down in municipal appeals work that all of those pieces that we fought so hard for to make sure that everything was rowing in the same direction for those things that aren't getting appealed, but that are going through what should be a smooth regulatory process are not going to happen. So I'd love to just have some thought around what that means, especially because if the LURB is an expert in Act 250 and now has to become an expert in 250 different land use.
And let me just respond to that
Yeah.
one particular point, because the composition of the board, with Kirsten Sultana, just being district coordinator for almost 20 years. I was the land use attorney who did zoning and Act 50, a lot more zoning, because there is more zoning to be done. The other three members of the board, this was by design by the legislature, are local and regional planning people that have written, many of the ordinances that we have in zoning. This is their bill. And so this combination of 5 different people with complementary backgrounds and experiences, we have 3 people that are municipal experts. And
Currently.
Yeah,
I mean,
currently.
we have to make law for.
Right.
That's right. Well, yeah, I mean, there's a lot of different expertises in the statute that.
Yeah, you're right. It's sort of, it's a laundry list. And that's one of the challenges that we have in terms of like trying to even conceptualize this is it's not dependent on the individuals that happen to be there right now. It is, we're looking at a system and the credentials and the composition of that board is very important to the success if we're going to take on those municipal appeals. So, as I sit here today, and, we have a wildlife biologist, we have, 2 certified floodplain experts, Kirsten being one of them. She is licensed engineer, or maybe I don't have the right terminology.
I've done the class to see it though.
Okay, she has the experience, Sarah has certified. So, but whatever that board is going to be at any given time, that's important to continue to have that, in our rules, or if you're good, make sure that that continues if these kinds of tasks or jobs are given to this board. Really essential. Because I absolutely, I thought about this in so many different ways.
Okay, so sharing that's though a concern, that if the majority of things that are appealed are local land use, and that is now going to the LURB, what is the time? What does that mean for the LURBs? Do they just become an appellate board? Is there still the capacity to do those other pieces, which I know were important to our organization? And maybe it's, yes, we have great staff and they will ensure that where we hear our experience at this commission is wildly different than at this commission. We'd rather do housing projects here than here because of that. Like that predictability is part of what we push, why we said, yes, we would love to see a 5-person board. So that's a concern. I also want to, is the next model your model too that we haven't scrolled down to yet?
It's just a kind of an illustration of the idea of having multiple pathways.
Yeah, because the jurisdictional opinions, I talked about last time. Going for reconsideration. Because I do think that's an important piece of this puzzle. I know that was the Putney, and as we look at the tier 1 and even like tier 2 jurisdictional opinion, do we have fewer than 800 feet or not? Pretty. And is your proposal here that it just goes, like a JO would just go to the board and then that's the end of it?
What I was trying to address is the fact that there seems to be significant variation among the district commissions around jurisdictional opinions.
Yeah.
And right now, the LURB has limited ability to influence that. And so one way or the other, whether they go directly, all of them go to the land use review board, or they go to the district commission, but are then reviewed by the land use review board. But I just feel like the LURB has to have some role in ensuring consistency in how jurisdictional opinions are.
Yeah, I don't want to come big and often.
No, that's something that we had talked about before, is having JOs be reconsidered by the board, and that's the.
I think having the LURB, as the appellate body would expedite, either way that David private, I think there would be lots of opportunity for that. But I just wanted to, like, I have to leave right at 4 because I've got.
Oh, my gosh, I'm sorry, please.
Okay.
Take,
I mean-
take the floor.
No, I don't want to just rush through my thing, so maybe we could do it next time, but I would like to say that, I think, B&R's proposal, like, the core of it is that, to make its point, totally valid points about, making sure that the LURB can perform the functions that it has now statutorily. But I do think that, it could, I think, the way it's set up, and everyone keeps calling the LURB a lay board. And I guess that means that they're not a lawyer board, I guess, is that what I'll interpret it as, but they're professional. You're not a lay board. It's not the 9-member environmental board from the 1970s and 80s. It's a different animal and altogether. And I think with hearing officers and or administrative law judges, I mean, clearly we heard earlier, and I think you really said it well, the system, the fact that like what people said was a worst case scenario happened, the system is not constructed the right way. I think, my analysis has been from the beginning that we have 2 judges, we ask them to treat everything the same way, whether it's a setback dispute or if it's a giant priority housing project or a Walmart or a quarry, it's all the same. Like, you could use hearing officers without disrupting the board's ability to perform its other functions, to dispose of, smaller, more resolvable cases. As Ron has been saying, if housing is a priority, you could tell the board to make housing a priority in focusing on those appeals. And I think if we're going to stay, I agree with David, the record review, de novo review debate, we've had it since as long as I've been in Vermont working on these issues, which is 30 years now. If you're going to have a de novo review, I think you need a way to expedite all of those appeals coming from the zoning boards around land use, if you really want to get at the housing issue and the inefficiencies in those systems. And so, I mean, next time I could go through like in more detail how I'm thinking about it, but I do think that the board, which is going through the tier 1 mapping review is intense right now. That's not going to be forever. Like, it's going to be a very big year for the board getting through that tier 1 mapping. And once it's done, they have to be reviewed every 10 years? They get reviewed 8 years?
Yeah.
So there's going to be more resources available. Right now, I think the board is developing, working on this appeal study, working on some other studies, doing the tier 1 mapping, developing the tier 3 rules and the forest fragmentation rules. So yes, right now the load is heavy, but once the board gets through that, you're going to have 5 professional board members and staff, and we could look at how much additional staff would be needed if they're really going to hear appeals of all the land use decisions. But I do think that I do see that it's very feasible, and I think it would be a lot more opportunity to create efficiencies in the system than just tinkering with the court rules, because that's the only other way to do it. If you keep it at the court, the only answer is, well, could we limit discovery? Could we expedite process in some way? I just think that it's very limited in terms of what you're able to do if you're in that court structure. But I've got like 4 more minutes and I'll stay into the bitter end. But maybe next time if we want to start with,
Brooke, can I respond quickly to Maine's point about the kind of the burden? Which I don't disagree that there's a potential additional burden on the LURB, but I do think we've got multiple bottlenecks for any project, for your constituents or the housing developers or anybody who's applying for permits. And almost anything that requires an Act 250 permit requires some local approval. So if we fix Act 250 and we don't fix the other part, then we haven't really addressed the kind of issue of like, how do we advance, predictable development that fits within the, kind of parameters the legislature sets up for that. So I feel like let's try to fix those 2 things together. And to me, leaving the local decisions left to the environmental court process and just fixing Act 250 wouldn't really solve the issue. So if we need to give more resources to the LURB to be able to do the municipal review, so be it. I haven't gone through the process of thinking through the resource demands of this, and I think the questions that Liam or Chris or folks have raised are good ones. I don't want to I wouldn't want to create a new process that slow things down at the same pace that are currently.
I think that's the, yeah, I think those are the questions we just have to dig into. It's, we're just not shifting the same load to a new problem.
Or just along those same lines, and I've been thinking of, sitting here saying, I know what everyone's gonna say, or largely what people are gonna say, so I apologize for being really quiet. Having worked on this for 25 years now.
You can read my
also-
mind.
What's that?
You can read my mind.
Pretty much. But I'm wondering also how the work stream or appeal stream shifts as we implement tier one, as we implement the road rule, which is gonna dramatically increase Act 250 jurisdiction. So that's something I think to keep in mind. Some of the municipal appeals, I would hope, in tier one areas where we want to build stuff, should be diminished by that work. Conversely, the tier three piece may, depending on how it's defined, may greatly increase. We're talking about single family homes or smaller types of things that are gonna find their way to Act 250. So something else to just think about as we're looking at what are the pipelines for appeals and who's handling them is how is that gonna shift? I don't know, we can completely predict what it is, what it's gonna look like, but we know it's gonna change. It's designed to change. If it doesn't.
Right. And there'll be less Act 250 appeals because of tier one as well.
There should be.
Right.
But on the flip side, with a road rule, there could be a whole lot of
Road
smaller.
rules, very
projects.
narrow appeals transition. That's how I'm gonna leave it, right there. I want to sit for the live stream out there.
Thanks so much.
Yeah.
Well, it looks like it is 4:00. Is there anyone else, members of the public or any of our stakeholders who would like to say anything else? Oh, I'm sorry, Ron.
Just, these are very picky, but, in terms of the standard review, you know, yeah, I think a town should be given some deference or whatever, but I also wanted to just throw out the concept that maybe there could be two different standards of review. I'd be hesitant to use this, learning to have to defer on Act 250 issues to a district commission. I think your job is to unify the commissions and to set the policy. I think it could be fine to set some type of deferential standard or arbitrary increases for a DRB decision.
And Ron, just a friendly amendment. I mean, there's also a distinction between the standard review is applied to facts and standard review with regard to law. So there's no question that LURB should have absolute de novo standard review on the law.
And then in response to Annette's comment, I've had this before the PUC all the time. It's really complicated and it's not particularly citizen friendly. Land use is a more accessible topic, and I recall David's model is building in a mediator, an ombudsman to make it easier for citizens to participate, which the PUC process does not. And the PUC analogy only goes so far as.
Oh, yeah. Yeah, and I want to be really clear about my analogizing to the PUC. I am not in any way suggesting that their process be imported, because that, I think, is what alienates folks and, pushes them out of the system. It was the structural notion of the recommendation in the hearing officer. So. Any other comments from anyone online?
Well, I'm just gonna mention, do we want to call out the media public comment in case there were folks that were not stakeholders that didn't get an opportunity to comment, which I think is what you're doing, but I just want to point that out explicitly.
Yeah, let me say a little more. Billy has his hand raised, but I do want to make.
Just at some point, it would be helpful to understand what the end game is for this process and how many more times we'll meet and how a decision will be reached. So that doesn't have to happen today, but at some point sooner than later, that would be helpful.
Well, right now we have the 23rd of June scheduled for our next stakeholder meeting. That's how many that we had scheduled were for, not that was all we were going to do. But we wanted to see where we were getting in the process before we planned additional times to get together. We were planning later in the reporting process to absolutely have a public hearing on it and feedback and all of that. You all tell me what you would like to do, but I think perhaps getting to the next meeting and trying to finish up with John's presentation and having further discussion about this. Maybe what we need to continue on the 23rd. And we can either decide now or decide on that day where we're at and how we would like to proceed, if we felt like breakout groups or smaller discussion groups on specific topics was desired, or if we wanted to come back as a full group. I am open and willing to do whatever people think would be useful and helpful. Because the board wants to embrace all the ideas, and like I said, we did get into a lot of debate about court versus board today. But I do want to move forward with creating those models and options that can be looked at, analyzed, so that the board will have information upon which to ultimately make recommendations. So does anyone have any thoughts? Billy, do you have any thoughts about, would you like other meetings set up at this point, or perhaps it would be best on the 23rd to sort of determine where we're at and how the group would like to proceed?
Yeah, I think that's fine. Just at some point, it would be helpful to understand if your intent is for the LURB to be making a recommendation in your report, and if so, how this group weighs in on that. Or if you're just going to put out the options that you've heard without any sort of value associated with them.
With any sort of what associated?
Without any like value associated with them. So if you are going to be making an affirmative recommendation, it would be helpful to know that and understand what the process is for the stakeholders to kind of weigh in on that before it's finalized.
Right, that's why what we're contemplating is drafting reports in a few months.
Okay.
Having actual meetings with the stakeholders in almost a hearing setting with the entire board present, so that all of the board members can hear based on whatever draft information we pull together. Maybe if we end up with 2 board models, maybe it will be, gee, these are the 2 we're looking at. Can you folks tell us what you're thinking about them? The board wants very much to involve all of the stakeholders, and honestly, we have such a brain trust of knowledge that has been wonderfully shared with us, and all of you folks are spending your time and energy on this, and we really appreciate this. But the board believes that this is a report that is our report to make recommendations, and absent the board, I'm one board member, but absent some alteration in the understanding of our charge, we believe that it is our responsibility to make recommendations to the legislature. And we'll take input, feedback, comments, but it is a LURB decision. This is not a consensus report.
Yep, thank you. I understand that.
I would just encourage that. I mean, as a legislator, I can't obviously interpret the law as a single legislator, but it's sort of frustrating. We had this happen in general in housing where a long-awaited report from a study group, a summer study group, came in, and it really was a compendium of what everybody thought. There were no recommendations. And it's just the problem. We've all read the report, but you kind of know what people think anyway. It's you want a recommendation or 2 or whatever. But yeah, I think that's great.
Excellent. Well, the next meeting will be in this location again, here in Randolph at Vermont State University, Randolph campus. And we will also have the online option, of course. So really look forward to the next opportunity, and we will get out some materials. This particular meeting, we have recorded it, and we're actually going to be doing meeting notes through the recording that we have of it. We're going to try an AI function which actually might be an experiment about what might be possible at the municipal level for creating records. I understand it's working pretty well in some contexts, so AI isn't the answer to everything perfectly, but we're going to give that a shot. So thank you very much, everyone, for attending, and you have a wonderful afternoon.
Thank you.
Appreciate all the input so much. Thank you.